suppose initially I just want to start with saying that I'm a bit personally confused about where we're starting off in relation to this bill. I think it's glaringly obvious that the coroner inquests are required at all sites. Just to give three brief reasons for that, I suppose that is the law. You just referred to the Coroner's Act, Minister. It even goes as far as to specify that if somebody dies in state care or custody, the coroner is obliged to act. Secondly, I suppose the lack of information on the causes of death. The abnormally high death rate in mother and baby institutions clearly demonstrates a high likelihood of negligence. We have a lack of information on locations of burials. All of these would highlight the absolute necessity of the coroner being integrally involved. And thirdly, then, all of the experts that came before the committee outlined the need for the coroner to be involved. And yet this bill says that it suspends coronial jurisdiction and disapplies the coroner. I know you just mentioned there that it's not going to intervene with the coroner acting, but is the plan for the new agency to exhume, identify and reinter remains, and then perhaps for the coroner to go and do the same again? Like, what is the purpose of disapplying the coroner from this bill? I'm yet to understand what the actual purpose of that is. And then in your statement you said it's vital to intervene at Tuam, but that other known sites will be left to the discretion of the government, and you just alluded to that again. That is a complete abdication of responsibility. I think in essence you're saying we have to do something at Tuam, but we'll decide on the rest depending on public pressure. Like, there is already laws in place in relation to the Coroner's Act. Why is it at the discretion of the Minister at the time? And I just, basically, you're saying it's vital to intervene at Tuam and it's not vital at every other site, and you're legislating to remove laws which will ensure that this will happen. And I feel like we'd have to forgive people for wondering if it's by design that it's another attempt to kind of do the bare minimum, to wait and see what the pressure is, just deal with Tuam. And I suppose the key question, Minister, is why not bring the coroner's powers into this agency? Why do it separately and say that this won't disapply the coroner when it says in the bill that it suspends coronial jurisdiction? I don't understand.
Thanks very much, Deputy. I suppose on the specific point of the two references to the disapplication of coronial jurisdiction, what we're looking to address there is a situation where we want this agency to be able to intervene and exhume. From a legal point of view, it's regarded as inappropriate that at the same time the coroner would have also a jurisdiction and the local authority would have a jurisdiction, because in terms of exhumation, we're not just disapplying coronial jurisdiction to exhume, we're also disapplying the local authority jurisdiction to exhume. Again, in terms of identification, this agency is going to have very significant powers based on legislation to undertake a DNA based identification program, and that program is not one that would traditionally be open to the coroner. So again, the identification powers that the coroner has under the existing Act would be disapplied, so there wouldn't be concurrent jurisdiction. But in terms of any other powers the coroner has under the Consolidated Coroners Acts, those aren't being impacted by what's proposed within the draft head of this legislation. In terms of a decision to intervene, I don't think it can be a matter of just leaving it up to public pressure, and I don't agree with that take on what's been done here. What we're seeking to achieve is to set out clear criteria within the legislation which will guide this government or future governments in terms of its decision as to whether to intervene in a particular site or not. I think we all accept that those criteria have been reached in Tuam. We don't know if they'll be reached in other sites. But I think it's important to say that that's why this bill wasn't designed as a Tuam specific as a Tuam specific piece of legislation. It was designed in a way to be cognizant of the fact that there may be future sites where there is a need to intervene, and I think I suppose it is conscious just for us to remember that. Whereas in Tuam, I think there is that almost unanimous agreement, particularly among relatives of survivors, about the need to intervene. That same degree of I suppose agreement among relatives isn't necessarily presently in existence for all other sites, and that's why I suppose those various criteria need to be there and need to be considered.
Sorry, ultimately, what do you classify as vital then in this situation? If it's vital in Tuam, like is the classification for vital not the fact that we know that there is very likely death due to negligence? We know that people want to find out the fate of their disappeared relatives. And in some instances, then it might not be vital, but it is in Tuam. Is that what you're saying?
No, what I'm saying
so it is vital in every scenario.
Sorry, Deputy, I talked over you there. Would you mind just repeating the last part of your question?
I'm wondering if you think it's vital to find the fate of the disappeared in each site in the country, or do you just think it's vital for Tuam?
What we're seeking to do in Tuam is, again, looking at the manifestly inappropriate nature of the burials of these babies and children at the Tuam site, and that is what this legislation is designed to address. Situations where the burials of children and babies who are in mother and baby institutions or county institutions are in a manifestly inappropriate manner, and that's fundamentally what this legislation seeks to achieve. And as I say, I think there is general agreement that manifestly inappropriate standard is clearly evident in Tuam, but this legislation allows for the fact that a similar situation may be revealed elsewhere, and will allow a future government intervene elsewhere.
Sorry, time. I'm going to have to move on.
Thank you, Chair. I have so many questions. I'm not sure where to start, but I suppose, Minister, I'm wondering, do you see the importance of this legislation and the exhumation and identification of remains? Is the importance on that for you based on families finding out where their disappeared relatives are? Or is it more to do with the way in which the unmarked graves came about, like whether it's in an unmarked site or in, for example, a septic tank? Which is the important reason for this bill? Is it based more on how the unmarked graves came about, literally, in relation to what the layout of them is, or is it ultimately important to you because we can help people find out where their disappeared relatives are? What is the thing that makes it more vital for you?
Well, look, it's I suppose the reasoning behind this legislation, I think, is ultimately an understanding that was felt across the entire country, and a repugnance that was felt across the entire country when it became clear in 2014, 2015, following the work of Catherine Corliss and others, that infants, children, that their remains were treated in such an appalling manner. Not only were they, I suppose, denied the both the collective nature of the burials, the location of the burials, everything is, I suppose, deeply repugnant to our notions of decency. And I think it was on that basis that this legislation is being brought forward, and that need for the families of those who were born in Tuam to have some reassurance that those remains would be treated in a dignified manner by the state, and to make provision for that.
And do you think that it's still vital for families to find out where their disappeared relatives are, regardless of the nature of the unmarked grave? That it's equally vital for those people to know?
I hope in the context of the interventions that we undertake in Tuam or in any other sites where a decision is made to intervene, I hope we're in the position to provide information about and potentially provide families with the remains of infants and children who died in these institutions, bearing in mind I suppose the concerns that were flagged by a number of deputies earlier in terms of the potential success or otherwise of DNA and other identification techniques.
I take it that means you believe it's also just as vital, regardless of the nature of the unmarked grave, as vital in each site as in Tuam. I suppose just another question. I'm wondering why there isn't a clear right of access to information in the bill for relatives, and maybe that's not necessary. I'm just asking why that isn't in the bill or in the other one. And you spoke about that it would be inappropriate for 3 bodies to be involved around an exhumation identification process. So does that mean that if the coroner does decide to act in relation to any of the sites that are examined by this agency, that they will have to wait until the agency is finished, because it's inappropriate, as you say, to have more than one body involved at one time? And would that then result in bodies being exhumed, identified and reinterred, and then that happening again if the coroner were to get involved? Or is the coroner allowed to come in during the process that the agency is undertaking? And therefore, if that is the case, why then is it inappropriate to have more than one body involved at any one time?
The comment I made about 3 bodies involved in one time is specifically in terms of their exhumation powers. And that's what we're seeking to address in terms of the exclusion, the disapplication of the coroner's exhumation power and the disapplication of the local authority's exhumation power. In terms of the coroner conducting its wider investigatory powers, there is no clash as regards that and the role of the agency. So I don't see a need for the situation that you outlined there to take place.
So the 2 bodies can be involved at the same time?
So the 2 bodies are doing 2 different things. So it's not a case of bodies doing the same thing.
So would you consider bringing the powers of the coroner into the agency rather than keeping them separate if the 2 are allowed to work together after exhumation?
Well, I think, the understanding is that the powers of the coroner already apply. It is the jurisdiction of the coroner already exists. So to repeat those powers within the context of the agency, I'm not sure what the clear benefit of repeating those particular powers are in the particular circumstances. But as I said earlier on, if there are concerns in terms of the information that the agency discovers in the context of its work, if there are concerns that wouldn't be available to state bodies, we can certainly look at drafting any relevant provisions that would ensure there's full cooperation between the agency and all other state bodies.
Okay, there, just in the interest of fairness, if there's anybody else, then that